Faculty. I always like to start with the spirit of the program, or at least my impression and belief the spirit of the program. It's to help students understand the role and function of the court in our society, our community, make sure they have investment and appreciate and respect how that process is supposed to work and their role as a citizen in it. In order to do that, I believe it's important for them to understand the fundamental process and the rules. So if they're ever brought into a situation involving courts, that they have at least that basic understanding so that they can make the experience, or they can benefit, and it will help them if they're ever taken into court or if they go to law school and explore options for their future. You as attorneys, from the attorney perspective, bring to this effort your expertise, knowledge as an attorney. Your role is very distinct from the faculty advisor, who you should rely on to give you the tools that kids you need, the resources you need, the classroom, the scheduling, and the interaction with the students. So you bring your understanding of the evidence code and your ability to analyze to the faculty and to the kids. I like to stress also that from an attorney perspective, you're not aware of the intricacies and rules of the school system, specifically the district, and you need to be aware and allow the faculty to advise you on that. When I was coaching, I coached for 14 years and relied on my faculty advisor to make sure I understood what the rules of the school were. Things, very subtle things sometimes, like don't be in a room with a student by yourself. Always have a third party or another adult in the room, especially if you're a male attorney with a young female, a juvenile female. We can all understand why that's important. And those are the things that the faculty has to bring to you, because I didn't think about that. I'd go out in the hallway with a young student to help her do her direct examination or work through an opening statement, and it'd be noisy in the hallway. And I go, well, let's just, we're working at 6 o'clock at night. I go, let's just go across the hallway into one of the classrooms where it'll be quieter and we can focus. Very bad idea. Faculty says, Barker, don't do that. And I understand that. And by the way, this is my wife, Stephanie. She's also a very accomplished trial lawyer, too. She coached with me for 12 of the 14. And she was also very good at reminding me about the rules, because I got kind of animated. And I'm sure she's going to step in here at any point. But that's the role of the faculty versus the attorney advisor. The most important thing to remember is that the students do the work. We had coaches who worked with us who, in dealing with the students, recognized that the students didn't have a solid grasp of the evidence code, which they shouldn't or wouldn't. And it was easier for a lawyer just to do the work, just to sit down, take a voluntary statement from the package, and basically draft a direct examination, and then hand it to the kid and say, here's your direct, or here's your cross, here's your opening, here's your closing. It's just easier for a lawyer to do that, and that's a violation of the rule. The rule requires, the mock trial rule requires that the student do the work, that they benefit from their effort and energy, or they suffer as a function of their lack of focus. And you have to let that happen in order to respect the rules of the court or the rules of the process. And that can be very frustrating. It requires a great degree of patience for you to sit there and listen to a student repeatedly stumble through a direct examination and know how much you could do it better. And you as a coach can show them how to do it. You can pick up the work they've done and say, how about this? How about that? Think about this. Think about where you are in terms of whatever the issue is. You can bring your knowledge, experience, expertise to them as a coach. You just can't do their job for them.
You kind of have to step into a teacher role with them, which is something as practitioners we tend to not do. And so you kind of have to move back into that teacher-mentor mode where you walk through okay, if you're going to ask the questions this way, let me start making the objections or be the witness that has to struggle with answering those questions so you can help them understand why that structure isn't working, and that'll help them step back and then want to fix it. So that mentor process with them can be, or model it. Okay, if I were going to ask a witness questions and you can't do their witness, but here are ways you could go at it differently. You step back into that teacher role with them.
And that also requires coordination with your faculty advisor, your teacher, because you'll have a student one day who will do great work. You'll be excited about the effort, and then because they're kids, the next time they come in, they have forgotten everything they apparently knew from the first. And what you need, if you see that, or suddenly something happens in your view to this student that changes your perceptions, that's where your faculty will come in. And you go to your teacher and say, Johnny's not doing what Johnny did before. And the teacher, and I had this happen, teachers say, well, Johnny and Janet, they're dating. And Johnny and Janet just dumped Johnny, and Johnny's very emotionally upset about Janet. Or, there's interpersonal stuff that goes on in the team that you really don't want to know about. But your faculty wouldn't possibly know, and you just need to know that you need to give Johnny a little bit of patience. Or she'll know, or he'll know, the faculty will know that the intricacies of intricacies of that relationship or that situation, and help you respond appropriately to the student's need. So that's another point where the faculty comes in. Stephanie. I'm just trying to think where else to go. Tools. Some of the things that our faculty would do for us. We talked about videotaping, because a student will learn well if they're able to perform and then watch themselves do that work. A student you've got to be able to balance. When you put a team of 8 in a room and you have one performing in front of 7, 7 students can be very critical of the efforts done. And so you need to be aware of whether that situation is a positive one or not, and adjust accordingly. You need to obviously understand that this is a game. This is not a real trial. So you need to be aware of the strategy and tactics that will help your team perform. Because ultimately what we're looking for is a score. We're not looking for a verdict. We're not looking for a guilty or not guilty. We're not looking for a damage award. You're looking for a 10 for each student. So understand that it's about a score. It's about presenting to your jury, who are professional lawyers who are scoring, what those lawyers believe should be, they should see and understand that the student has presented. So like in an opening statement, you want to make sure that there's a theme to the opening statement, that there's a concise presentation and an understanding of what the opening statement is. It's not an argument. It's a presentation in anticipation of evidence. So they have to do first-person future. You're about to hear evidence, or testimony will be X, not argumentative, declarative statements like you do in closing. So make sure, lawyers, that you're teaching your kids that, because they won't understand that subtlety. And that will dramatically affect their score if they're being scored appropriately. Direct examination, cross-examination. Lawyers, you do it as a function of work, probably more, your mind is churning. You're working your facts, you're understanding the evidence code. Kids don't work that way. Kids generally need to follow a script. They need to have you work to a point with them where they kind of have a good understanding of the rules, but apply the facts to them and work off a piece of paper. Many kids want to have that script. They want to have that crutch. So you have to assess your kids. Do they need a script? Can they work on a narrative? And you have to assess all that as a function of preparing them.
One of the things that I find challenging with the kids is, and one of the benefits of this program, is they have to be able to argue or present both sides of this case. And you'll have a single affidavit for each witness, and the witnesses are designated as witnesses on either side of the case. But there's good information in that affidavit for both sides of the case, and there's bad information in those affidavits for both sides of the case. And so one of the things it teaches the kids to do, and you kind of have to walk through with them, is how to analyze a statement from both sides of an issue. How do you argue this position with just this information, and how do you take that same information and argue the other side of it? Because they're going to have to flip back and forth depending on which round they're in. And so part of your working with them is to get them to look at that statement of facts, a lot of which has totally irrelevant information in it, and decide what they're going to use, pick out how they can make that pitch, and then learn how to argue this case from both sides of it, so that you kind of get their mind thinking back and forth. And I think that's one of the most difficult things for the kids to do, because they tend to want to own a position, and at the end of the day they can't. Or they can, but they can only do it temporarily. Then they have to own the other side of the position. And so walking them through that. The other piece that I found somewhat of a struggle when I started doing this is, at the end of the day, it really is a competition. And the next piece of this we've added this year, we're going to walk through what that competition process is and how you earn your points. What points get allotted to each section, because every kid's got a role. We tend to get focused as lawyers on the lawyers. Your witnesses, your student witnesses, are going to be key to your score. We win and lose competitions most commonly based on the witness scores. The lawyers are important, and they got to know the technicalities and the mechanics, and that's all stuff the lawyer coaches can help with. Getting your witnesses to emote, to express appropriate emotion, to be the serious analytical expert when they need to be, can be really challenging. So if you've got kids with a drama bent in your group, and you're trying to figure out where to assign roles, where are they going to fit, your drama kids are going to be great witnesses for you. Last year, I think 2 of the outstanding witnesses at the competition were experts, because they learned all of those technical facts. There were a couple of them that, as you said, in the competition, you begin to think they're real, because they knew what they were doing so well. So don't lose sight in your prep and assignment, and work with your kids about the importance of those witnesses, because we tend, as the lawyers, to get focused on the attorneys, and they're part of it, but our scores hinge on those kids frequently.
And that's an interesting point. Faculty, it's necessary for you to bring your knowledge of the kids. Do they have a drama background? Can you, your student body, can you reach out? If you're weak on your witnesses, can you reach out in your student body and convince kids to volunteer for the program, to make your witness, bring in a more compelling witness, somebody who has that talent. And that's, again, where the faculty has been very helpful, because, again, they'll know what the kids that are out there and maybe be able to recruit. Let's focus on some of the technicalities and mock rules. For instance, you're going to have to be aware that mock trial has very unique rules in terms of day of competition. You've got to make sure that none of your kids have any identifiers. They're wearing no identifiers of their school. You have to make sure that the audience members, the parents who are so proud of their kids, who come to observe the process, don't have any identifiers of their schools.
And that your high school principal doesn't show up with his ball cap and T-shirt.
And we had that happen. One of the first years, our principal walked in the door wearing his colors.
Flying colors.
And we had to send him out, have him turn his T-shirt inside out and put his hat in the car, because that's a violation of the rules. And believe me, if you're up against a team that's skilled in the competition, the coaches, their attorney coaches and faculty, will be very aware of it, and they'll call a technical on you. And it's a terrible thing to happen when your kids work so hard, and then all of a sudden they're in a position where they have to defend a technical violation, and they really didn't anticipate it. Another one that we've had is students are not permitted to speak with faculty or attorney coaches during the competition. And I had a situation where a student asked me, turned around about halfway through the competition and needed to go to the bathroom. He said, "Can I go to the bathroom?" I can't answer that question. And we drew a technical challenge objection from the other team because the attorney coach saw it happen and called a technical on us. I don't remember what the result was. It wasn't significant, but it throws a spin into the process. And there are many, frankly, of those technical violations.
The other thing I'd recommend, and I had not done this the first couple of years because I had some experienced coaches I was working with, and then I finally read the mock trial competition rules. Something you need to do and something you need to have at least one of your attorneys on both sides of your case have done. Because once the competition starts, they're on their own. You're in the back of the room, biting your nails, hiding your head, trying not to talk. And they've got to handle it, and they've got to handle all of the rules violations that occur as well. We had one year where we had relatively new kids on the squad, and the other team came in and they read through their rosters. And as you walk through this, you've got to have a different student assigned to each witness on each side, and then 3 lawyers at the table. Well, as they read through the roster, they identified one of the witnesses they were going to call as a witness that was supposed to be on their squad side, because they didn't realize you can't pick of the 6 which ones you want, and they thought one of the defense witnesses was going to make a better plaintiff's witness, and so they called them in the other side, and they identified to the court they were going to do this. Now, our little attorney, our lead attorney, looked at that, and she said, wait a minute, that's our witness, and stood up and called the rules violation and said, they can't do that, that's our witness. We knew in the back of the room it was happening, but you as the coach or the teacher coach can't tell them that, because once it starts and the judge calls things into session, you've got duct tape on your mouth. And so your kids need to know what the rules are and to watch for those things. So somebody needs to walk through the procedural rules of the competition with at least one of your lawyers on both sides of the case, preferably all of them, because they'll each catch things, the others don't. And because this is a competition, we get focused as the lawyers on how they're going to present the case, and we get focused on the case, and of course we know all the rules in the courtroom. The rules are different in this context. Questions?
Yeah, you said students can't speak with attorney coaches during the competition. Between rounds?
Between rounds, you can talk to them all you want, and you should. Haul them out, beat them up, verbally, not physically.
No, not during a break. If the case is called, you can't touch them, you can't talk to them, verbal, nonverbal communication until the case is concluded. And then you can go out in the hallway. We always did a post-round debrief, always, because kids learn, they are sponges the day of competition. You'll have them for 4 months working hard with them, and you get nothing.
They learn more in round 1 than they learned in 3 months.
They learn more than round 1 because they have skin in the game. So that we found that to be critical in terms of dealing with our kids. But let's go through from the beginning to the end of the round, so you're kind of clear. First thing you need to make sure is that you have 6 kids. Each team needs to be composed of a minimum of 6 kids. You're going to have 3 witnesses and 3 lawyers. How you divide that up is going to be in the art of the prep. But you need a minimum of 6. We were lucky. We would routinely have 8. So you have backup kids, you have a timer available. So if somebody got sick, we try to have a bench, but you need to have 6. You need to have 3 attorneys. Again, 3 attorneys, 3 witnesses. I would advise you to designate when you set your team, have a first chair, second chair, third chair. Each attorney has to be responsible for the direct examination of one witness from your team, obviously, from your witness pool, and a cross-examination of your opposition's witnesses. So each lawyer is going to have the function of one direct and one cross. You're also going to have to identify 2 of your lawyers, one to do opening statement and one to do closing argument. The closing argument attorney does both opening, closing, and rebuttal. So they have to be prepared not only for the narrative in closing, opening, closing, and they have to be ready to do the unique rebuttal. Listen to your opposition, formulate a structure in response, and be prepared to stand up. Time limits on opening are 3 minutes. Time limit, and it's 3 minutes on the close too.
4.
4 minutes on the close? 4 minutes on the close. Sorry, I've been retired for 2 years, but 4 minutes on the close. It's critical under mock rules that in your closing argument, that when your attorney stands to do initial opening closing argument, that they reserve rebuttal time. That's unique to mock. It's not something that happens in the real world. So make sure your student is ready to get up and say, may I reserve any additional time or remaining time for rebuttal argument? Because under rules, and believe me, it may sound minor now, but it's huge when you get there, that you must affirmatively reserve time for rebuttal. And you should structure your closing argument, have your student structure closing argument, so they have approximately 30 to 45 seconds in rebuttal. So try to structure your narrative on opening closing to approximately 2 minutes, 15 seconds. And it comes down to seconds, guys, literally. You have a grace period under rule in opening and closing of 10 seconds. If you go over 10 seconds, you pull a penalty. If you're under 10-second penalty, there is no penalty. So we always try to get our kids, within 15 to 20 seconds. And we would sit there literally with stopwatches and time them as we drilled down to a final product, both in opening and closing.
Your penalties come in the form of point deductions depending on how much you go over.
Witness presentation of evidence or case in chief section of the presentation, you have 20 minutes to do your direct examination of your 3 witnesses and 15 minutes on your cross-examination. And again, it's all time, so obviously you need 3 lawyers in the room, you need 3 witnesses in the room, you need a timer ready to present time, and be aggressive in that. We'll talk about that in a few minutes. The amount of time, the 20 minutes, you can use anywhere you want, because some witnesses are more valuable than other witnesses as a function of your presentation. So you might use 8 to 10 minutes on your first primary witness, maybe a critical eyewitness, and less time maybe on the expert and on the third collateral. I haven't been through this program or the problem, but commonly what we see is one primary eyewitness, usually either identified as a victim or an accused, and one expert witness, and then somebody who's usually collateral, like a character witness or somebody who has a more minor role. You have to decide as lawyers how your team is going to use their time. So don't think you have to take 20 divided by 3 and you have 6.5 minutes per witness, because that's not how it should work. Go ahead.
Do you decide how to order the witnesses?
Absolutely. You can take them any way you want, however you perceive it to your advantage in the presentation of the evidence. And again, that's where the lawyer come in.
The problem now designates which witnesses are plaintiff's witnesses and which witnesses are defense witnesses, so we don't get the confusion we had that year. And so you'll know which ones are yours, but how you use them, what information your kids pull out and glean from them, part of this is deciding what matters, what to use so that you can use that time efficiently.
The board they're very good at writing problems that offer, like Stephanie said, information that is important and critical to your evidence or your case from both sides, and then there's a lot of collateral chaff in there. So you as lawyers have to try to separate the wheat from the chaff, because your kids aren't going to know. There's going to be, I promise, there's going to be stuff in there that's really it would be fun, impeachment, probably character impeachment information in your program that probably isn't very relevant to the overall issue at hand. And your kids are going to want to go there. They're going to want their Perry Mason moment, okay? And you're going to have to figure out how much Perry Mason comes in, okay? Because, again, what you're looking for is a score from the attorneys who are going to know the difference between something that's relevant, more probative than prejudicial, versus more prejudicial than probative. Go ahead.
Question.
So my team has 8 students.
Perfect.
So then does that mean 2 of them will not participate? I mean, all 6 of them are there? Or
You can mix that up.
I can mix that up.
You can mix that up
6
so
of
that
them, are doing on the plaintiff side, and then maybe,
a different 6 of the 8, different subset of the 8 on the other side.
Okay.
And that
then
works well.
One of them needs to be the timekeeper.
No, what? Your timekeeper can... Go ahead.
And that can rotate between sides. So if you've got 6 of the 8 as plaintiffs, 3 lawyers, 3 witnesses, then one of the 2 that sits out can be the timer. If you mix that subset up the next time, somebody who presents on one side can time on the other.
And you should do that. Spread the responsibility around, because it's especially if you have you don't want one student doing both openings, or you don't want one student doing both closings. You want to spread that responsibility around, because it's a great responsibility in terms of
We've made that mistake. I've done that a couple of times, and it can be very overwhelming for the kids in the process.
Your students will be a lot stronger if they don't, as the judge said, just do one side. Because by having to learn both sides, when they get up to do their cross-examinations and to do their openings and closings, they'll understand the other side so much better that it will make their argument better when they, no matter which side they do. It just strengthens their argument.
So, go ahead.
So last year was my first year, so I'm kind of like, the alternate thing kind of confused me last year, so I still have a question about it. So I have 6 kids who make up the 3 and 3. I'm allowed up to 2 alternates.
Correct.
In the rules last year, it said if I have alternates, they must compete in at least one round at the competition.
Right, so if you've got 8 kids,
Right, no, yeah, I understand that, but how did, it was really hard for me to do that because mostly the reason I wanted alternates was to cover illness or a broken ankle or something like that, rather than your awesome idea, which you just presented, but I didn't have the talent, I guess, to go that deep.
so you pick a witness or a single examination on the other side of the case.
Right.
So that person who's your weaker person performs a more minor role
Right.
in the side they present.
And that's what I did. My question is, how are you guys in the tab room or wherever making sure that those of us who have alternates really made sure they competed to follow the rules? Because nobody ever came to me and said, oh, did she compete?
That's the simple answer. Nobody's cross-referencing the witness names to the kids on your roster.
The way it'll get noticed, frankly, when you start each round, for those of you that have done this, you'll remember this. You've got to give a roster to the judges at the beginning of each round so that they know of the 6 kids at each table who's who, right? You don't identify by school, but you give names and you identify who's performing which roles. And so if someone were to do a cross-reference of those roles, they would notice that you only had 6 kids performing in that process, even though you'd listed 8 on your competition team.
I've never seen, and
I don't know that anybody's ever done
I
that,
don't-
but that's where it would get caught.
But
So your students will probably be the first ones to tell you, because if they don't get to play, they'll tell you before we'll tell you.
And frankly, if you're lucky to have 8. You really want to spread the responsibility around, because I think ultimately you'll get a better product in terms of the competition. Because the kids get exhausted if you have 1 or 2 kids that are carrying the weight for the entire team. You want to try to spread it around.
But
Would be
that
my
having
advice.
been said, we've had teams that only have 6 kids.
Certainly.
Speaking of
You don't have to have
spreading
8.
Around, just to clarify, on the rebuttal argument, that has to be done by the closing lawyer.
Correct.
Correct.
It's-
And the
so it's
closing
one
and the
case.
opening can't be the same lawyer. They've got to be
Right.
different people.
Correct.
Just to help clarify that, the closing is only getting 1 score, and from the plaintiff prosecution side, they're getting 1 score that combines both the closing and the rebuttal together. They're
Correct.
getting separate scores. So that's why it has to be the same student, because they're only getting 1 score for it.
Correct.
Right, and in the long run, when you're thinking about rebuttal closing, most kids, if they're lucky, they leave themselves about 20 seconds. There's never much time for a rebuttal closing. In fact, sometimes you'll get a student, because we tell them, always use your rebuttal. I don't care if you stand up and say, thank you. Always use it because you want to have the last word. And some kids actually will stand up, and you'll see the card, will say 5 seconds, and they'll say, I think we should win, and they'll sit down. But there's really not much time for rebuttal at all. So.
That is true.
We used to try and, the purpose of it, you got to remember the purpose of the rebuttal is to respond to what's said in the other side's closing, right? So in theory, you as the lawyer kid sitting there should be listening to what they're saying so you can get up and point out where their argument's wrong in, your remaining 5-10 seconds. But if your kids are new to this, they struggle to do that. I mean, they're nervous enough that they're struggling to keep up with what they want to say, much less engage with the other side if they're new to this process. So we always had the kids have a little canned 5 or 10 second rebuttal that they knew they were going to be able to say because
that's
these
critical.
were the obvious arguments on the other side. So they'd have something ready to go. What we found was that increased their confidence level, and so at least 50% of the time they didn't use what they had ready to go because now they were focused on what the other side was going to say, and they'd come up with something generally far more creative than they'd prepared in class. So that helps them to think, but we had them prep something.
A couple of things we've tried and we debated. I don't know whether it was a good idea, bad idea, but for you to think about. You have an attorney on the plaintiff side, prosecution side. I guess this is a civil case, so it would be plaintiff side. And structure your presentation or tactically have that attorney maybe be the witness in the defense case for that same presentation. So the child would prepare it from the perspective of the attorney presenting the evidence in direct, and then possibly being the witness on the other side of the case. Because remember, everybody has to be ready to try both sides. Or have the role, it doesn't necessarily have to be the witness, maybe if they're going to be an attorney on both sides, be prepared to do a cross-examination of the witness so they become intimately familiar with that witness. Now that worked against us sometimes because
They'd forget.
the student would get lost in the function. They forget that they were a lawyer versus a witness, and so sometimes that got a little confusing. So you really have to know your student. You have to know your member.
And you got to be flexible with it, because we'd get halfway through and we'd have a lawyer prepped up to examine his witness and then cross-examine on the other side. And then on the flip side of the case, that lawyer would be the witness that he would otherwise be cross-examining on the other side of the case. And he'd get confused about what his role was, and it wasn't working. And so we had to shift it up and move people around. So sometimes you'll get in and you'll have things assigned and you'll think it's all good, and it's just not working. So you need to be flexible with what's going to work with your kids.
Does that make sense? I know that dynamic sounded a little strange, but what you're trying to do is allow the kids to maximize, I think, focus on a particular function. And the amount of information in terms of a witness, they can focus on the witness. I kind of like the idea, but we did struggle with that. The kids did
Depends on the kid.
Depends on the kid that struggle with it.
Do you guys have questions based on what you've seen in other competitions or issues that have come up that you wanted us to address with the group? Problems you've seen that you've learned as you've walked through this your first year or two?
Okay. Go.
Last year at state when we came down, and I think we've got this addressed, there was a list of objections that were on, I guess, on the website.
Right.
And,
13?
And have we got this addressed
Yes.
so that we can make any objections we want and are not limited to those? Because we didn't prep our kids on only making those objections. We said they could make any evidentiary objections, and we got chastised.
Because you were off list?
Yes.
We've had that same thing happen in a competition. The presentation we're going to do today goes through those recommended mock trial objections. I don't know that you're limited to them. Andrew's shaking his head.
Yeah,
We are?
because Dave thinks, Watsby, all my other coach, thinks that we can make any objections again. And I want to make sure we get that straight, because I don't want those kids in there. I had certain objections I wanted them to make about impeachment that are not on that list. And then we got,
All right.
judges.
So you have to work from the list of the 13.
Those are the 13, yeah. 'Cause we
Yeah,
want this-
that's fine. I just want to make sure that everybody's on the same page with that.
Let's.
And the reason is simple, is it's not fair if your team knows 15 objections that no one else knows.
Well, they're not. It's not that no one else knows them. They're in the. They're
Well, if
evidentiary
they're
objections.
in the evidence rules, if
Yeah.
they're an attorney, but not if you're in the mock trial competition. That's the problem.
They would never have been trained, they wouldn't be
Okay.
trained to know that.
Yeah, no, that's fine.
Sure, like for instance, one would never do a motion to dismiss, although in real life, in trial, you would do, whatever it is, the rule, like, motion for correcting verdict.
Well, but what I'm talking about is there was improper impeachment last year, and so we had trained our kids to watch for that. They made the objection, and we were chastised because that was not an objection on the list. And that is in the evidence code that you guys give us. Well,
No, I'm sorry. It is, no, I'm sorry.
like what I'm saying, so it's not that somebody couldn't anticipate that objection.
Just work off
Yeah, that's what I just-
everybody needs to work off the
Very clear on
13.
that, because-
Let's talk about objections.
We'll send out a clarification on that, because that's been a question we've had as we've walked through.
Let's,
I think sometimes the confusion gets that mock trial uses a simplified rule of evidence. It's not the entire rule of evidence.
Correct.
It's a simplified rule of evidence. So if the kids are making an objection and they are using the simplified rule of evidence and they're quoting something that's in the packet, then that's a fair game. There shouldn't be any chastisement for that. But if you are using something that's a part of the rule of evidence, that's not a part of the simplified rule of evidence, that's where the chastisement would come. That's where the point penalty would come from. Because it's really the simplified rule of evidence
let's, all right, stop. Let's talk about objections. We're going to take objections from two perspectives right now. Procedural perspectives pursuant to mock trial rule, and evidentiary objections as a function of the mock trial evidence rules, because they're very distinct and important. Number one, in real life, lawyers are commonly object an opening statement if they believe that information is being, there's a statement made that isn't supported by the evidence. It's routine. It's not appropriate to mock, okay? Your students, don't train your students to do a contemporaneous objection during opening or closing. They must, however, or should, note that objection and make it post-trial. So they can make an objection if I've been permitted, after evidence is closed and your presiding should call for any post-trial objections, could stand up and say, pursuant to the mock trial rule, I can't remember what it is, but it's identified. It's in the teens somewhere. If I had been permitted to object an opening statement, I would have objected that my opponent was argumentative or presented evidence that wasn't supported or made statements that weren't supported by the evidence. Whatever the objection that an attorney might make in opening has to be made post-trial. That's true also in closing. So if there's a contemporaneous objection that would be commonly made, they need to be trained by you to reserve that to the end. And you should be, in my opinion, aggressive, fairly aggressive and but respectful in your post-trial objections, because you can gain advantage there. It's not, a lot of teams aren't trained up on that, so my advice would be to spend some time thinking about those post-trial objections. It's critical for you to also understand that your presiding judge probably walked in the courthouse that morning, kind of got briefed up on the facts, maybe has a general understanding of the problem. They're really thinking about their trial on Monday or their deposition they're taking on Tuesday or the motion, their work, their life. They're not really focused tremendously on the problem. So you might have a student who gets a deer in the headlights look from a presiding judge when you're calling the intricacies of a mock trial rule. You need to train your students or have them understand that that's common in real life too. You might make a motion or stand up with objection and be overruled in that effort and be absolutely, your student might be incredulous that that was the right ruling or right objection and they weren't successful in it. You have to train them to understand that they have to be able to move and bend with the decisions and the realities in the room. So if they don't agree with something the presiding is saying, you, under decorum, have to teach them to be respectful. Don't roll the eyes or pull a tantrum.
Or thank the judge every time you lose an objection.
Yeah, don't do that.
One of the things that and I'm going to go back to this objection and evidence question. One of the things that we struggle to remember as lawyers in this process is you have now entered what we call mock trial world. And mock trial world is different than real world. The parameters are very different. And so we had that circumstance come up one year where my first year, like I said, I didn't read all the rules. And so I had the kids making objections to things coming in that I knew I'd make if I was standing in a courtroom. And they make the objection at competition. The other side stood up and said, that's not a mock trial objection. They can't use it. And we were told we couldn't go forward with that objection. So my adjustment next year was to sit down and go through the objection list. And if there was evidence we anticipated coming in that was improper, figure out how we were going to use one of those objections as our platform to get the issue to the judge. If the improper impeachment is because it's an improper character, if it calls for speculation, make something up so that you've got a mock trial platform to stand up and make your objection to the court. And part of what we have to do is figure out how to take what we know is our real world, what we would do in a courtroom, and plug it into mock trial world. And there's a way to do that, but that's why we've always got to keep in mind this is a competition with specific rules, because it's different.
Board, are there any other procedural issues that you've seen? Because then we're going to go where Stephanie just went with the evidentiary process.
Probably the toughest challenge for us on the board is trying to apply our rules. And Judge Barker started to talk about this. The issues about what you do after trial, the judge will say, are there any post-trial matters? Are there any rules violations? And Judge Barker mentioned that you would then say you would reserve your right. You would, at that time, state your objections had you been allowed to object to opening and closing. The trouble, though, is that many times that runs parallel, if you will, or it's confused with another set of rules violations, which is, are there any rules violations that either side wishes to make at this time? And that would be more rules-oriented. And I think what we need to do, this is just directed towards us, is I think we need to direct the judges to ask two different questions. Are there any post-trial matters that you want to bring, which would be if I've been allowed to object, and are there any rules violations? I don't know if we have enough time to talk about the procedure for rules violations.
Well, we really should, because remember, and I appreciate you bringing that up, remember what you're looking for is a score. So you want your kids to demonstrate to your jury, your lawyer score judges, that they understand the rules and they're applying them to what happened in court. So ultimately, that score could say, that was a 9. In my mind, that was a 9. But I agree with that points violation or that challenge, and so I'm going to make that closing argument an 8 or a 7 or whatever. Adjust from the reality. Also, under rules, the presiding judge can make a finding like a time violation, because you call for time violations too, and scores are deducted as a function of a time violation, and points are taken. And that needs to happen, especially the dynamic in terms of procedural violations, opening, closing, that needs to be addressed while the scoring judges are still there, because our reality in scoring is those scoring judges are very quick. They want to get those ballots scored, and so the kids are fighting about a potential rules violation, and the judges are over there scoring, and they're not. It doesn't really affect the score at all, because the ballots have already gone before the kids are even have a chance to address what they might perceive to be a procedural violation. And I hope I didn't just lose most of you. I think what I want to move into evidence violation or evidence objections and how to handle them. The problem will have situations where there are obvious objections that can be made on the evidence. And part of the exercise is having the kids demonstrate to your scoring judges that they understand the rules of evidence and that they're applying the rules of evidence to the facts of the case. So they'll stand up and say, objection, hearsay. And you'll want them, as they are capable of doing, to state the rule to the presiding judge so the scoring judges can hear it, and analyze the fact to the rule, to the point of law. So you'd want them to stand up and say, objection, hearsay. Your Honor, if the presiding wants to hear this, Your Honor, hearsay is an out-of-court statement offered to prove the truth of the matter asserted. The witness just indicated that she's testified to what someone said to them, on the road or wherever. Classic hearsay. Analyze, state the rule, state the fact that they're concerned about, bring those two together concisely and argue their point, and allow the presiding judge to rule, sustain or overrule. And your scores will improve if you demonstrate to your scoring judges that your kids have a basic understanding of the rules of evidence and they're applying them to the facts. That's really the one point I want to make, and it can be almost any of the rules or rules of evidence.
And then the attorney who's handling the other side, it would be proper for them then to stand up and say, Your Honor, may I respond? But you always want to, of course, ask the judge if they can do so. Most of our judges will usually let the students go through at least one round, state your objection, and then they'll usually give the other side a chance to, I guess, defend their question or what have you. But just, of course, always ask, permission to do that. And what I did also want to say, because Judge Barker says this, is unlike in real life, like if I'm trying a case in front of Judge Barker, I'm not going to stand up and tell Judge Barker what hearsay is, et cetera, et cetera. You'd say, counsel, I know very well what that is. But in my trial, and it's something actually I've had to learn, which is it is perfectly, not only is it acceptable to do that, but you want to do that. And if you do, by the way, get a judge who does not understand that and say, counsel, I understand what hearsay is, why you're reading that to me, the student is right.
But even though the student is right, they are in a courtroom, and that person on the bench who maybe never really read the rules of evidence is right in that courtroom, and so they have to be able to adjust. If that's what the judge wants, and that's how the judge is going to respond in a very negative fashion to what they're doing, that'll impact their score if they push back. And they're going to get lectured by their scoring judges about not being rude to the presiding bench. So your kids need to be able to adjust from judge to judge to judge, because as you have all seen if you've done this, it's very different from room to room.
One of the biggest problems I see with objections is some of the judges will say, you know what, I'm not going to rule on that right now, I'm going to see if you can lay that foundation. Or I'm going to let you re-bring that objection in just a second, let's see where they're going. And invariably the students will go to their next questions and forget to come back to it. And the judges, you can see the scoring judges, you can see the presiding judges, all on the edge of their seat just waiting for the objection to be made again, and they just don't think to go back. So when you're training your kids, if you're going to work on objections, try to work on an issue where there are objections made, the judge tells them to do something. You know what, lay some more foundation for me, and actually do it, even if it's off their script. That gets a lot of points. If you have to go off your script to do something what the judge asked you to do.
They forget to listen in multiple contexts. It's like Mr. Diamond says, they will get tied to their script and they stop listening. And if you can get them to listen, that's probably the ancillary long-term benefit of this process, is to get them to listen to what is being said in response to questions they're asking, or from a judge at the bench who's trying to give them some idea where they can go and make more points, how they can get around the problem. Because a lot of the judges know and understand and treat this as an educational process, and they're really trying to help. They got to listen.
All right. Some training things that we found helpful, if I recall, and there may be more advice. Take the 13 objections, make sure each of your kids have a copy of them. Make sure your kids, I would put the copy of those objections right in the middle of the table at competition, and I would train your kids the same way when you're working with them in practice. Have that single piece of paper listing all the objections up there so they can actually stare at it as they're listening to their opposition do their work.
The other thing I'm going to recommend that we've done a couple of times, by the time you get to competition, you are going to know which hearsay exceptions they're going to need to be able to use with regard to specific witnesses. So create your own list and annotate it and write in the rule. Rule 803, exception, subsection, whatever, write it out so that when they get in there and they get panicked and the evidence starts to come in, they're like, no, I know how I need to get this in. Here's my exception when they make the hearsay objection. They've got it written down, so you can help annotate that list for them, specifically tailored to this case.
So, because I also do We the People, so I'm just kind of trying to kind of compare what the kids can do. So they can have notes with them.
They can.
Whatever they need.
Okay, so they can have any kind of notes with them at the table, even if they're on the witness stand, they can have notes, so they're not memorizing them.
Not on the witness
Not on the
stand.
witness stand.
Okay, so the witnesses need to be...
The witnesses need to know who they
have
are.
nothing, but the attorneys can have notes.
Yes.
They can have their affidavit with them.
I don't think they can. They're treated like, well, they can have their attorney approach with the affidavit if they want to refresh.
Yes, but only to refresh. Sorry.
Well, or refresh or impeach. That is something that's more realistic in terms of the witness examination. So I don't think the witness takes notes. If they bring them, they certainly can't refer to them. They have to be turned over. They can't be sitting there reading from a script.
Yeah, you want You want your witnesses to know who they are.
What I think maybe, this is where I had maybe a little bit of trouble last year, and I just want to teach my kids writing.
Sure.
No, they're good
In
questions.
the real world, you can't refer to something unless it's for refreshing recollection or it's been admitted into evidence. And what happened is we had other teams, like, bringing up documents and talking about documents without admitting them, and maybe we didn't say the objections, I guess, in the exact correct way, that they were, that perhaps the 13, because we didn't know that it was only limited to that 13. And so that's why I think, and we'll fix that so we do it within the 13, but that's where kind of our issue came like, and that's where, because they were saying that's improper impeachment to bring up to refer to something, or it wasn't that specific objection, but you know what I'm saying. And so that's where we ran into some issues with the way that evidence was being used and documents were being used. And obviously that's something that may be...
Well, where you fall back, if they're bringing in documents and evidence that are outside the problem,
No, they were part of the problem, but I was saying this, they weren't laying the foundation properly to show a witness a statement to refresh recollection. There's a way to do it.
Right.
So if my team is objecting because they're not doing it properly, but it wasn't written in the 13 objections, that's where we ran into problems.
Well,
People weren't
then
refreshing.
take it off the list. Have your student
it a
briefed up on a
foundation
foundational
objection.
objection.
That's what I'm saying. I didn't, but that's where the issue came up for us last year, because it was a proper objection within the mock trial rules, but it wasn't listed as one of the 13. That is the issue I was having, and we'll fix it.
Right.
But that's one of the problems. I'm saying there are objections within the rules that maybe aren't written in the 13.
right,
Oh, absolutely. Other important points.
procedural.
Train your kids to follow procedural protocol. When they stand up to make an objection, make sure they stand up and they own the room. You don't want a kid standing up saying, I think that's hearsay. Okay, you want them, just like a lawyer, you want them up on their feet answering, owning the room. Objection, and you don't teach them to do a speaking objection. The lawyer just said that the witness said X and Y. No, you stand up, you state objection, and you state a basis for the objection. Then you engage with the presiding, as you should as a lawyer. If the presiding wants more, then they'll ask for more. And if you stand in opposition to the objection that's posed, you need to stand up and state your response. I talked about hearsay very quickly before, but that's a classic example. If the objection's hearsay, make sure your kids are ready to respond with an exception if you believe it's a hearsay. If it is hearsay, but you haven't recognized exception under the rule, or if you don't believe it's substantive, if you believe it's substantive non-hearsay, admission of a party opponent, declaration, or a statement made in accordance furtherance of the conspiracy, I don't care. If you don't believe it's hearsay, make sure your kid is ready to say, it's not hearsay, Your Honor, 803, and have them prepped to stand and own the question and allow the procedure to move forward. Mock is very similar in real life in another aspect. If they own the room and they act like they know what they're doing, then the presiding will go that way. Presiding is, I can tell you, I've been doing it a long time now. If you own the room and you sound like you understand the rule, you're further along in the process, okay? And so
Your kids are going to know these rules better than the judges do. They just are. And so to
Not all
the
of the
extent
judges.
they can cite them, well,
Never mind. I think we've
to
already
the
blown our
extent they
time
can
here.
cite them and reference them, they're going to be ahead.
Are there
We're
any
done.
questions? I want to invite you all, if you have questions, I'm available. The board, I know, to the extent within the rule, are available to answer procedural questions too. You are not alone in this effort. So reach out. Contact information is provided.
I
Yes.
have one quick question. This is from a few years ago, but since I'm taking over now, I want to make sure I understand. I was told a few years ago that there was some controversy and some team called an objection to another team because they had their papers in those 3-hole punch sleeves.
Really?
Is that modifying the...
No.
No.
Is that okay?
Yes. Don't use if they're demonstrative, and there usually are demonstrative exhibits, charts, graphs, maps. Use what's given to you by the board. Don't blow them up.
Can't
and-
highlight them, you
Yeah.
can't alter
Just-
them.
Did those little
Yes. Yes. No.
Effective sleep, yes, but an evidence notebook, no. We've actually, because years ago, we had some teams
Oh.
would actually come in and they would have these brilliantly organized notebooks. I think they even had a seal on them. I don't know where they got the seal from, but it just looked so good. And we said, no. We know what you're
So you
trying to
can't
do.
pass out evidence books. You got to use the documents one at a time.
No PowerPoints in opening and closing. Kids are going to want to do that, but you can under the current rules. Just use the exhibits as they've been prepared.
We also had questions come up last year about use of electronics in the courtrooms because the kids will be taking their notes on their. Drove me insane. They'd come in with their computers. They got all their notes on the computers. The computer would crash. They couldn't practice because they. Anyway, they can't have electronic equipment to assist them in the courtroom. They can't have their laptop at the desk. Their notes need to be hard copied if they're going to use notes. No phones. None of that kind of thing. We realize in the real world we're all using that stuff, but in the context of the competition, it's very difficult to police whether or not there are communications going on that shouldn't be. So in the context of the competition, they can't have electronic assistive devices with them. No iPads, no.
And the final comment I want to make that I try to always stress, this effort is about the students and the kids. This effort is about how I started our little quick talk here, about making the kids understand how important the role of the courts are in our society and having them invested in that effort and a basic understanding. It's not about you beating the guy on the other team, the other coach, because you saw him at lunch and he talked some smack to you. It's not about, really, it's not about fundamentally, in my opinion, somebody who's first, second, or third. Although when I was a coach, I wanted to be first. I always did. I wanted my kids, obviously, to do the best they could. But it's about the education, the experience. And so keep that in mind. Make it a positive experience. You, frankly, as attorneys, learn a great deal from this effort. This is not all give. I say you take a tremendous amount from this effort. There's nothing more valuable when I was a practicing trial lawyer than to sit down with a kid and try to explain what relevancy is. And the difference between 401 or 48035, the state code versus the federal code, to explain what relevance is, to go over the basic fundamental structure of the evidence code over and over again. And it's critical. I still benefit from it as a trial judge because I spent years teaching high school kids and trying to explain it to smart kids how to apply a particular exception to the hearsay rule to facts. So you get a lot out of this effort, and you give a lot as well. You should, what?
Or 10 minutes of
Be treated with respect. If you need advice, don't hesitate to reach out.